everyone, it's Trace McMillan, and today we are doing a webinar on separation. Now, let's talk about dividing your assets formally. There is no such thing as a gentleman's agreement or an informal division of your assets. If you think that there is, then you are playing a very dangerous game of Russian roulette. And I've seen it come back to bite people on the backside many years later, and it's not an uncommon experience. So let's say you have an agreement between you and your partner. You go, right, okay, you're going to keep the house, I'm going to pay you out $100,000, here you go. You forget to transfer the house out of one person's name into the other, or let's say you even do that. But you don't go through, you don't formalize the actual agreement. And then let's say 5 years down the track, all of a sudden there's been a property explosion, the market's gone sky high through the roof, which up until COVID used to happen. Then what happens is the person who was paid out that money says, well, no, they've got a really great deal now, so they can come back at you and ask for more money because you actually haven't divided up your assets formally. And the thing about it is when you divide your assets formally, the asset value goes not from the date of separation, it goes from the date of the agreement, which means if you don't go through and divide your assets until 5 years after you've separated, then the assets are the assets that exist in 5 years' time. Now, how you do this formally is this. There are only 3 ways you can formalize your property settlement. So one is by going through, and the most common way is to go through and do a consent order. So that is exactly as it sounds. It is where you both go, right, this is how we want to divide up our assets. You say, yep, you sign it, you say, yeah, I'm happy for that order to be in place. The other party signs it and says, yep, I agree, love the work, yep, I completely agree. It gets sent off to the court. The court go through and they actually assess it in accordance with the rules under the family court. And as long as they consider that what you're proposing in the division would be in a range of something which is just and equitable, then they will put a beautiful red round stamp on it. It gets sent back to you and you now have a formal consent order. Now, if you are in agreements, but there are some tricky little complex issues with your property division, that's okay. There is another way to do it, which is what we call a binding financial agreement. You'd probably know it more locally as a prenuptial agreement, okay? But it's a prenuptial agreement that's done after you've separated. Now, with that, if you wanted that, it doesn't go off to the court. It's not a formal order like a consent order that goes off to the court, but it's equally binding. But you both must have separate lawyers who provide individual advice as to the pros and cons of that agreement. And when you both sign that agreement, it will be binding on both of you. Okay, so that's another option, but that's where you both have to agree. Now, if you don't come to an agreement about what you should be doing in terms of your property settlement, then what you have to do is you have to have gone through and applied to the court for the court to make an order and a judgment to decide how your assets are divided. Okay, they're the only 3 ways. So if a judge makes that order by consent, it's called a consent order. If a judge makes that order and it's not by consent, then that's just called a court order. It has the same impact. If you don't have either of those, the only other way is through a binding financial agreement where you both have received legal advice and it's all been signed up in a formal document. The question as to when you're going to go and divide your assets then, yes, so there's a few things. If you're a de facto relationship, your time limit is you have 2 years from the date of separation to have gone through and divided up your assets. That's as simple as it is. If you're married, however, you have all the time in the world up until you have gone 1 year after you've gotten your divorce. So you don't have to get your divorce until at any time. Your minimum is that you have to be separated for 1 year and 1 day. But apart from that, you don't actually have to go through and get a divorce, which means if you haven't gone through and done your property settlement and you don't get a divorce for 20 years, What that means is that person can come back at you and ask for a property settlement and more money from you for 21 years. So that's a big period of time, and that's a big risk to you. So again, you can do it any time from the time that you separate, but you want to do it as quickly as possible to make it cleaner, simpler, and less complicated.